more true with indoor air. And this is really the crucial distinction as opposed to outdoor air. You know, outdoor air suffers from what Aristotle called the tragedy of the commons. The idea that nobody really owns the outdoor air, and so when you pollute into it, you could harm a lot of people. The indoor air, on the other hand, is perfectly self-contained. The idea is that there is a property right, and you can either make yourself amenable to the indoor air or avoid it entirely, and then the property owner can make beneficial use of that indoor air as well. And so this is the intrinsic limit of government regulation. The idea that police power is limited by the nuisance theory on the one hand, and then secondly, that the coming to the nuisance theory further limits the ability of Ohioans to complain and try to regulate certain business and property that may even be a nuisance in some sense. But there's also extrinsic limits, and again, this works just like the federal Constitution. So if you're challenging a federal regulation, it's a two-tier process. One, does the government have the power to implement this regulation? And then two, even if so, do I have a right that's protected that I can assert here? Again, going back to the healthcare litigation, even if the government's found to have the power under the Commerce Clause to force you to buy a corporate insurance policy, you may then say, I have a right under substantive due process, or equal protection, or the Fifth Amendment, or some other right that prohibits you from exercising this power against me. The same is true at the state level, and that's the fundamental right to use property. And this is what the smoking ban interferes with. It indicates that you have the right to hold the title to your property if you're a bar owner, but you don't have the right to choose how to allocate your indoor air, which can be extremely economically gainful or extremely devastating if you take that right away. And this is the idea that you're taking a fundamental stick out of that bundle of property rights. And of course, we sometimes forget that. We view property rights as mere ownership. But again, the Ohio Supreme Court has acknowledged that ownership doesn't matter very much. All the way back in 1874, the Supreme Court said it is a transparent fallacy to say that there is no taking because the land itself is not taken. The idea is simply, if you own a hammer, but you're not permitted to use that hammer, the fact that you own the hammer no longer matters very much. And that's the situation we find ourselves in with the smoking ban, is that there's a fundamental right to use property, and that's deprived by the ban. And there are a bunch of technical reasons why there are problems here, and we can get into kind of the policy discussion of the bans if you like, whether they actually protect public health, etc. But there are three main arguments that are really raised to support smoking bans. The first is that you're protecting the patrons, and as we already discussed, the patrons acquiesce voluntarily or not. The second is that you're protecting the employees, and the same is true. The employees voluntarily acquiesce to expose themselves to that environment, and often earn higher rents, or higher wages, if you will, because of that exposure, much like coal miners can demand higher wages because they're subject to worse air quality than other members of society. And the third argument is the externality cost, the notion that allowing people to be exposed to smoking indoors will create worse health in society, and that's borne by all of us, the taxpayers. The problem with that is that the smoking ban doesn't actually reduce rates of smoking. All it does is simply determine where people smoke. Economists have studied the issue and found that the number of cigarette packs bought in a particular state is unchanged before and after a smoking ban. And in Ohio, smoking rates have been on the decline for a long time, but much like environmental regulations in 1970, the same phenomenon has occurred. In other words, air pollution levels were drastically declining before 1970 when the federal government implemented the Air Pollution Controls, Clean Air Act, Clean Water Act, and then they continue to decline, and so the federal regulators take credit for that decline when it was already occurring. The same is true of smoking bans. Smoking was actually declining at a more drastic rate before the implementation of the Ohio smoking ban than since then. So there's no evidence that it actually stopped smoking. And then there are a whole myriad of epidemiological issues, but there's really one key issue that does play a role in our litigation a little bit, And that's the idea that acute and sporadic exposure to secondhand smoke has never been proven to be harmful. And there's no doubt that secondhand smoke is harmful. We would never argue that in court. That would be a kind of foolish position to take, and we'd be laughed out of the court because it's universally understood at this point that that is the case. But there is absolutely no evidence that if you're in a bar for a few hours a week, or even if you work there for a few years while you're working with your college or law school or whatever it is, that you'll suffer any kinds of effects whatsoever from secondhand smoke. So the idea that there's some sort of a public harm is also mitigated by that evidence. I like to think of it as kind of like the argument that bar stools may not be great for your back. You know, sitting in a bar stool for a great number of hours may eventually cause bad posture or scoliosis that you have to have treated. And that comes out of either your wallet or the public's wallet to take care of you. But that doesn't mean we should ban bar stools and require certain types of seating in bars because you're only there for a few hours. And so what it comes down to is the notion that when you're regulating a fundamental right such as the right to use property in Ohio, the regulation can't be unreasonable and it can't be arbitrary. And the space we're talking about here is space where only 21 and over individuals go, driven by liquor sales. Liquor consumption being far more harmful in many ways than smoking consumption. And the two essentially having gone hand in hand since the time of the Founding Fathers. In fact, far beyond that. I think I'll stop there just with a few caveats. I think that there's a slippery slope argument that everybody's aware of when you're talking about the smoking ban. The notion is that you should not be able to dictate the terms of how another runs their business. And I think of the bar market, or the tavern market in Ohio, as similar to the cereal aisle in a grocery store. You know, you look at the cereal aisle and you have a voluminous number of choices. And what you don't do is say, there are thousands of choices here. I like Raisin Bran the best, but I hate the raisins. So I'm going to pass a regulation that forces Kellogg's to take the raisins out of Raisin Bran so that I can then buy it and enjoy it. Well, government does not exist to create amenities and comfort for you. It exists to protect rights. And you also wouldn't walk into a bar and demand they change the music because you don't like, for example, if you don't like rap music, you may try to pass an initiative that indicates no bar should be permitted to play rap music. Again, the answer, just as with the Raisin Bran, is don't buy it, buy something else. And the answer is the same. If you don't like the music at a particular establishment, you don't pass an ordinance to change it. You go somewhere else. And this is true even if it's a loud dance club where the music's ringing in your ears. Arguably, there's a public health consequence there, right? But instead of trying to control that, as long as that music doesn't pour out into the neighboring properties, what we do is allow for a variety of choices and options, and for people to pick and choose what they like and don't like, and simply avoid what could otherwise be viewed as a nuisance. You know, one issue that's in play here that's kind of interesting. This is a majority passed statute. In other words, the voters voted narrowly for the smoking ban in 2006. So at first blush, that would seem to raise some of the issues that are popular right now in California with Prop 8, the gay marriage amendment. But the issue is actually very different. Out there, the issue is whether the federal constitution prohibits the state from depriving homosexuals of certain rights. And the issue here is not that at all. Ohio has a process where you can pass a constitutional amendment by the voters. But you can also just pass a statute by the voters. And this is just a statute. So what that means is that it's still subject to the Ohio Constitution and the Ohio Constitution's protections, which trump that. And of course, the entire purpose of the Constitution is to protect the rights of the minority from the prerogatives of the majority. We would never look at an initiative to try to institute slavery and say, well, you know, it was badly passed by the voters. We can't do anything about it. The people have spoken. We would, of course, use the Constitution to protect people against those rights. And we should do the same here. With that said, I'm happy to handle any questions about the state constitution or about smoking bans in general. Yes, sir.
Well, I know your topic was mainly about bars, which seems like a fairly black and white kind of thing. I wonder what your opinion would be about somewhere. One of your main arguments for bars is that you have no the right to go there, not forced to go there. What about somewhere like a grocery store where it's kind of more ambiguous? You know, you couldn't say we have the right to go to a grocery store and shop. All the grocery stores in town allow smoking. What do you think should be the outcome there?
Yeah, I think that's a great question. There are these whole ambiguous sets of property. Grocery stores, restaurants are a great example. Think of a Bob Evans, for example. And I think when most people think of the smoking ban, they think, I don't want to, while I'm killing my biscuits and gravy, I don't want to be choking down smoke at the same time, which, again, kind of ironic because the biscuits and gravy is probably worse for you. But the idea, I think that the distinguishing characteristic that we're using for our litigation is places where children go. You know, if you want to make the argument, look, we should protect the children, that argument certainly does not apply to a 21 and over bar the same way that it applies to a Bob Evans or a grocery store. Now that's the litigation position. If I take a step back and answer your questions from the proper moral and constitutional perspective, there should be no difference. Grocery stores are private property, restaurants are private property, and the solution, if you disapprove of the smoking in those places, is to simply not go there. And what we find, and what our expert economists testified to at trial in this matter, was that the sorting process really works. In other words, if you allow smoking and society disapproves of that, they won't shop at your, or they won't frequent your store, and you'll lose clients, you lose customers. And at the same time, establishments that voluntarily ban smoking can do very well if lots of people prefer a smoke-free environment. And I'm certainly in that camp. I usually give this caveat at the beginning: I don't smoke. I find it despotic and despicable. I hate being around it. You know, my dad smokes a few packs a day, and I can't stay with him when I go home. You know, so this is not about some fundamental right to smoke. It's merely about the owner's right to choose more than anything. Does that answer your question?
Yeah.
Thanks.
Is there an analogy to, like, you know, in Ohio, for instance, we're in a state that provides, you know, greater rights for me to exercise my Second Amendment rights and carry concealed where I want to, and do it if I have the right license. And this is the first state. I'm from Arizona, and this is the first state I've really been to that I've seen a lot of stickers on the windows of private establishments saying that we don't want you to have a gun on our establishment premises. So, you know, I choose not to do my business there sometimes, or I just leave it in the car. But that seems to work well in Ohio. It seems like as there's greater rights given to those to exercise their Second Amendment right, private establishments decide to exercise their right to say this is the way that we want to operate, and it works. I just kind of want to add that seems to work in the gun sphere. I'm sure it would work in the smoking sphere as well.
Yeah, we're actually using the concealed carry analogy in our litigation, so that's an excellent point. An interesting aside to on the gun rights issue, Second Amendment issues, whatever you want to call them, in Ohio, the Heller case was a big deal, finding that there's an individual right to bear arms. Ohio had that same ruling in 1994. Section 4 of Article 1 of the Ohio Constitution provides for the right to self-defense and the right to bear arms. And all the way back in 1994, 14 years earlier, the Ohio Supreme Court indicated this is a fundamental right under our Constitution. So that's another example of state courts going above and beyond in the protection of individual rights beyond the federal baseline. And that's exactly right. Actually, interestingly, there's a bill in the state legislature that would require bar owners to allow concealed carry people within those bars. And I think that that's actually a violation of property rights. You should be free to choose whether or not to allow people with guns on your property. Particularly, they might be drinking, although I think the exemption is they can't be consuming alcohol if they've got the gun on your property. But it is essentially the same argument, that you vote with your feet when you're in the marketplace. Yes, sir?
What if there's not really much of a choice? What if it's not like the cereal aisle? Like, if you don't want Raisin Bran, you can go get Corn Flakes. But maybe there's, you mentioned that businesses can do well even if if they decide voluntarily not to allow smoking. But maybe it's not the same choice. It's, I think, contract adhesion from the consumer standpoint, not from the business standpoint. And I'm not going to make my decision to go to a bar based on the smoking, where my friends are going, maybe the atmosphere, and if I want to go whitewater rafting, I kind of